Okay, Executive Director Nevitt, what is next on our calendar?
Well, I've gotten some, although time is short, I've also gotten some requests for a real break as some folks have not had the opportunity to have any break for lunch.
Okay,
And we are going to move the late fee discussion to tomorrow. So we could do a break. We could go to the judges serving on the board discussion. I've been keeping our public commenter apprised of the timing for that. And then we would go to our meeting with Idaho.
all right, so it is now is it 2:30 now?
Yes.
So if it's 2:30 now, we take a half an hour break. Yeah, half an hour break to get us till 3. Then we're going to have 15 minutes for discussing the pro tem judge's issue. We're all talking mountain time. So Executive Director Nevitt, is 15 minutes enough for that discussion?
Well, I don't know that it's enough in time, but we do have a large amount of time set aside for Idaho. I think we could probably sneak 15 minutes into that and start that conversation at 3:30. Also, I do think, this is an initial discussion on the judge's policy. We may, so I don't think we anticipated at the executive committee we would finish it today.
This is, I think, somewhat of an issue that's going to cause a lot of discussion, and I don't want to short shrift it in any manner. Is this something that we could put off to perhaps tomorrow or another meeting altogether?
I think, I think well, actually, I see Mr. Galanda is here now.
We could give Mr. Galanda a few minutes of time now and then take our break in 15 minutes. All right, Mr. Galanda, are you there?
I am. Thank you.
Right. You bet. Why don't you go ahead and introduce yourself and give us a little bit of a guidance as to what this proposal is about.
Wonderful. Thank you all, and thanks to staff. I'd like to thank Governors Higginson and Williams-Ruth for supporting this policy, at least thus far. I am the proponent of this policy, and I will briefly share with you the story of an on-the-ground, unjust legal situation that is happening in real time, because it forms the basis for my advocacy for this policy. And I won't name names, and I do not wish to just besmirch anybody, but I am aware that my remarks will not allow complete anonymity to those involved, but I will do my best. In 2018, WSBA ODC wrote about a tribe that I've been involved with for the last 6 years in human rights litigation. That's the Nooksack tribe, calling the Nooksack, quote, justice system, meaning the words justice systems were in quotes, calling it probably not worthy of that description. And that disarray within the Nooksack judiciary has been very public within our bar since about 2018. In 2019, a past president of the WSBA BOG accepted a pro tem position with the Nooksack judiciary while still sitting as WSBA president. And it's the wearing of both hats, as I'll explain, that causes concern about conflicts of interest and appearance of fairness, or more specifically, appearances of unfairness at the WSBA. In 2017, a Nooksack single mother, who is my client, sought a domestic violence protection order against her child's father in the Nooksack tribal court. She's a political dissident at Nooksack who's criticized that tribe for violating people's human rights. The then chief judge initiated, rather than an adjudication of the domestic violence protection order, really retaliated against her by initiating sua sponte, a parenting action against her, meaning he converted a plea for DV protection into a challenge to the custody of her daughter. In doing so, he ignored a 2015 Whatcom County Superior Court order that gave her custody and the jurisdictional impact of that matter. He then caused her to appear in front of him in what was originally a parenting matter and ultimately a criminal custodial interference matter almost monthly for the next 2 years. In the summer of 2019, she was away on what's called Canoe Journey, where all the tribes in the Pacific Northwest really stop everything they're doing to engage in an intertribal ritual on the water by way of canoe. Most courts shut down during that time period, given the importance of that ceremony to all the tribes. The Nooksack court did not. And although she was represented by a public defender, having been then charged with custodial interference for violating the orders he had been meting out in the new parenting action, even though the public defender appeared for her, the judge issued a FTA, meaning failure to appear arrest warrant, because she did not appear. I then attempted to appear for her in habeas corpus to challenge her false arrest and imprisonment in July of 2019. My appearance was rejected by the tribal court. I sought writ of mandamus to the Court of Appeals to have the court compelled to hear my petition for habeas corpus on her behalf, which was also rejected. She then filed a pro se habeas corpus petition. And upon the ex parte advice between the tribe's defense lawyer and in-house attorney and a tribal clerk, that petition has sat idle now for the last 2 years. The persecution is so pervasive that my client has since relinquished her citizenship at Nooksack to, quote unquote, in her words, seek asylum with the Lummi Nation. This is where the WSBA becomes implicated. She has also filed bar complaints against both the chief judge and the tribal attorney who was advising the court clerk, essentially for subverting justice by way of the RPCs. She has since sought habeas corpus from the U.S. District Court, where I have been allowed to appear on her behalf. That caused the chief judge to recuse himself, meaning both the bar complaint and the federal habeas action, and to install the then sitting WSBA president as pro tem over her case. So he began sitting as pro tem judge, despite the admonition from the WSBA that this is not a worthy justice system, while he was WSBA president. My client continues to get hailed into tribal court. She was there as recent as Monday. She'll be hailed back next week or next month, while her pro se habeas corpus petition sits idle. The court will not take action on it. Meanwhile, she's not being criminally charged with this failure to appear, so she cannot challenge the situation that way. The matter is now headed to the Ninth Circuit on the question of the tribal court's bad faith, and the WSBA features prominently in that appeal. First, the past WSBA president sitting as pro tem and now being named as a federal respondent. And secondly, as you might expect on the question of judicial bad faith, ODC's 2018 indictment of the Nooksack quote unquote justice system not being worthy of that description is in play before the Ninth Circuit. I bring this to your attention because it, of course, impacts or affects the reputation of the WSBA. My client is concerned about conflicts of interests when folks are wearing multiple hats, such as this case with the sitting WSBA president also sitting as pro tem judge. Concerned that somebody would accept a position with a court when the WSBA has rendered unkind words about that particular court as a matter of professionalism and professional conduct. She's concerned ultimately that there are bar complaints pending before the ODC, which I know are walled off from the regulatory body that is the BOG, but she still has some concerns about appearance of fairness as it converges there at ODC. In short, this policy would prevent such a situation from repeating while encouraging pro tem judicial colleagues of ours to serve on the BOG or as BOG president. I would confess this case might seem sui generis given what I've described to you. I assume it's sort of shocking to hear that this could unfold within our state bar or even within the judicial system of a local tribal court. But I don't believe it's inconceivable that citizens could otherwise feel disenfranchised by way of some other WSBA president or BOG member while they might sit as a pro tem judge. Certainly our municipal courts are not above reproach. There have been learning lessons we've all witnessed in municipal courts in very recent years. In the final analysis, this is an appearance of fairness issue and the reputation of the WSBA and its BOG that I and you hold dear. And with that, I'd be happy to answer any questions, and I do appreciate your time and your consideration.
Thank you, Mr. Galanda. Open this up to questions from any of the Board of Governors. All right, I'm not seeing any. Thank you, Mr. Galanda. We appreciate you spending your time this afternoon. Governor Williams-Ruth.
sorry, Kyle, and this is not directly a question to Mr. Glenda, but as he mentioned, both Governor Higginson and I had an opportunity to talk with him generally about this topic over the summer. And one of the questions that has kind of percolated in my head is the overall appearance, and that we as BOG members, there's a specific bylaw that states that we as BOG members are prohibited from assisting anyone with any complaints filed with ODC for the 3 years that we serve, and then for 3 years after we've served, because of the potential appearance that we would have some undue influence on Doug Ende's office, which just we all know is not true because of his iron fist of separation. But again, it's the appearance that we deal with, and this was something I was discussed and learned in depth about earlier in my term. And so I guess for me, when having this conversation over the summer, this made me kind of wonder as to why there's not a similar policy where if it's not even if there's an actual conflict, but the appearance of, and if that's what if our bylaws are written to address those potential appearances, why not in this type of situation? So that's one of the questions that I was hoping that we would be able to kind of ferret out and discuss more here at the BOG level.
Thank you, Governor Williams-Ruth. Anybody else have any thoughts, questions, or concerns? Governor Gerbicki.
I'd like to hear from someone in opposition to the proposed language at page 52. I look at it and it seems like a reasonable approach, but I'd like to hear the other side of it.
I understand that WSBA staff has been looking at the proposal, have some concerns about practical aspects of enforceability and how it would be managed, and requires additional time to make an analysis of that and then probably present to the Board of Governors.
So is this something that we should table until September so that staff can give us a full report?
Governor
Is that what you're saying?
Governor Williams-Ruth?
Well, I was going to just echo with Governor Gerbicki. Is this something that the staff thinks that they might be able to have a discussion on and the impacts and practical abilities of that in September, or would they need additional time maybe to the November meeting? My goal, and I'll say the reason that Governor Higginson and I have pushed this forward is that Mr. Glenda has been very patient with us. Again, my own personal schedule problems back from April. This has been an issue long going, and so we wanted to start the ball rolling here at the BOG level, and knowing that it wouldn't necessarily be ripe for action today, but I would love to know if we have a ballpark as to when we can come back in and kind of dive in. Is a month enough, or do we need to go to the meeting after that?
Executive Director Nevitt.
Thank you. I just wanted to clarify that the concerns are merely technical. It's just a question of where to put it and how, exactly how different mechanics might work. So I think at the executive committee, we had discussed continuing the discussion into September. So that's what we were aiming for. I think September is ample. And I think we wanted to make sure that the board had an opportunity to hear from Mr. Galanda, as well as, if there was any additional feedback we wanted to take into account, including perhaps whether it should be expanded beyond pro tem service, or if excluding it to pro tem service was the right approach.
Thank you, Executive Director Nevitt. Governor Dresden, followed by Governor McBride.
Thank you, President Schicchetti. Yeah, I think I'm not sure that I have a problem with the language. I think that, or at least the underlying philosophy behind the language, which is that it's not stating that pro tem service is a per se disqualification. It's just requiring disclosure. I do think the language could perhaps be a little less vague, and I guess that's perhaps what some of what the staff is going to be doing. But so I think that's my comment.
Thank you, Governor Dresden. Governor McBride.
Thank you, Mr. President. So I'm looking at this language, and I guess I'm a little unclear. The language seems to speak to serving as a pro tem, and the issue seems to be tied to a specific case or individual. So does the language need to be tightened up a little bit that it's not about serving as a pro tem, it's about if you end up with a case that I think this is probably an ongoing disclosure obligation. You know, what if the case comes up a year after you're serving on the board of governors or something? So I'm just not sure that language, it seems to assume we know what's going to happen down the road, and I'm not sure we do. Is there any thoughts on that? Because I haven't looked at this language as long as some of you.
Governor McBride, are you directing that toward a particular Mr. Galanda or Executive Director?
Oh, Mr. Galanda, it'd be great if he has thoughts on that.
Yeah, thank you, Mr. Governor. Yeah, the idea was that if a situation arose where a sitting governor had an opportunity to become a pro tem, which generally should be encouraged, that there be a pause to consider whether that could implicate the WSBA at every level, or I suppose even the judge or his or her seat. Or likewise, if a BOG member was going to become president sort of while in service and had an opportunity to become a pro tem, which of course, again, should be encouraged, to at least have a moment of pause to make sure that that does not create any appearance of fairness issues for the WSBA.
Follow-up question, Mr. President?
Yes, go ahead.
So I guess that gets me to the point of thinking about, we can have someone run to serve as a board of governor who's an existing pro tem already, and we can have someone that takes that position while serving as a board of governor, and the conflict might arise well after either of those points, either initial election as a serving pro tem, after serving as a pro tem. So it seems like the direction should be at whether the case or the individual creates a conflict. I just don't know how to separate those issues, and I'll think about it, but thank you.
Thank you, Governor McBride. Any other questions? Governor Knight.
Thank you, President Cicchetti. I just wanted to make sure I understood the use of some of the language where it says pro tem who is a practicing attorney. So I think what we're talking about there is someone who is active status on their license status. Is that right?
That was my intention. Yes.
Certainly, if you have a judicial status, by separate rule, you cannot serve on the board.
Correct. And I was trying to recognize that in perhaps not as adroitly as possible, but using the language here, recognizing that sitting judges cannot preside on the board.
Sure. Okay. Yeah. To keep it consistent, one suggestion would be to use the license status type, because I believe that's the judicial status is another place in the bylaws. But I certainly understand exactly what you're saying here. Thank you.
Wonderful. Thank you.
Governor McBride, do you still have your hand up? All right. Any final thoughts? All right. Once again, thank you, Mr. Galanda, for coming and speaking with us this afternoon. We have a little bit more work to do with this one, and we'll be back in touch with you on our further course of action.
Thank you, Mr. President. Thank you all. Have a wonderful weekend.
You too. Okay, it is 2:45. Executive Director Nevitt, do we still need a half an hour break?
I think it would be good if we can afford it. I think certain folks like our Rex Nolte have not had a chance to really take a break yet today.
Well, so we'll blame it on Rex. I don't know whether we need to tackle, the what's the next one? Proposed amendments to the late fee waiver policy. We've already moved that one, right?
Yes. So all we have left is the meeting with Idaho, which is at 3:15.
3:15. So let's adjourn until 3:15 and we'll reconvene then. All right. Thank you. We're at recess.